All right, ladies and gentlemen, what I would like for you to do is to please go around the room and share your background and general impressions of the case. Thank you, beginning with Anila.
Using microphone too.
Well, my name's Anila Kedrapat. I'm a part-time realtor and a mom. My general impression of the case, in the nutshell, was if the antitrust law is to promote competition and protect consumers, on a high level, the supposed agreement between the two drug companies failed that law on both counts. Thank you.
Hi, my name is Andrew McDonald. I'm a government employee and married father of 4 children. When I first read the instructions at the beginning of the case, I thought the defendant, that the hospital was correct in suing for antitrust competition. But after reviewing the trial, I agree with the defendants that I don't think that there was antitrust violations, and then I think that it was just basically a business decision between the two companies it was just basically a business decision and didn't affect competition.
My name is Margaret Schmidt.
Margaret, speak into the
Okay. My name is Margaret Schmidt, and I'm a part-time Spanish teacher. Well, I think from the very beginning, I did not think that the plaintiff had a case. I just, like you, I thought it was a business decision, and I think in the end, consumers wound up getting a better price, at least a lower price, and I just didn't think it was there was much there.
Margaret, could you also share a little bit about your background for the benefit of all in the room, please?
Mm-hmm.
Thank you.
Yep, I'm a teacher, basically, a Spanish teacher. I have always had some job. I have 2 children. My husband works for the government. That sort of, yep.
Thank you.
Is that good?
Hello, my name is Michael Sangelo. I'm a project manager and have an engineering background, married with 3 kids. As far as my general impressions, I thought everything was very interesting, well presented. However, I kept going back to risk mitigation, and I felt that Kesso was really in a situation where they had to mitigate risk, and since the outcome of the patent infringement case was not known, they really had, it felt like it came down to a business decision to mitigate risk.
Hello, my name is George, born and raised in Rockville, Maryland. I am disabled, married, no children. I have some training in computer repair. About the case, it was very compelling, both sides. And while I thought the plaintiff did have some evidence, I don't think it was enough to prove to the point.
Thank you, George. Eric?
Oh, yes,
Please.
I'm sorry. My name's Eric Axelrod. I live in Rockville. I'm not married. I work as a housing specialist for HOC Housing Opportunities Commission in Montgomery County. We deal with affordable housing and of all kinds in Montgomery County. I consider myself well-read, and I try to read up on all kinds of different issues outside my what I do. This was an interesting case. There was a lot to take in. I generally am of the opinion that that they didn't really prove their case enough to me to show that there was harm in the competition. It seems to me that this was, this was basically a reasonable kind of agreement that they came to. Nothing to me, when looking at the details of the agreement, seemed to be out of place. It seemed to be an idea that made sense to both sides, and I don't see that there was a lot of harm. However, I think that this shouldn't be a cut and dry kind of thing. I think maybe we could look at some things more just to make sure that we're making the right choice, but I don't believe that the prosecution proved their case.
The plaintiff, you mean?
Plaintiff.
Yes, thank you, Eric.
Hi, my name is Soma Bernard. I'm a stay-at-home mom and a homeschool teacher. I have 3 kids, and I agree with a lot of my partners here that I don't believe that there was any illegal action. I thought that it was a business decision that makes sense to both parties, and I do agree with that.
Thank you. Could you share your marital status with everyone?
Married.
Thank you so much.
Hello, my name is Tamika Harris. I'm 32 years old, single mom of 3. I live in Maryland. I also agree. I feel as though it was a business decision as far as money-wise. I don't think it was like the type of settlement where they really sat down, talked it out. I think it was all about money, and that's my statement.
Hi, my name is Betty McBride. I live in Washington, D.C., originally from the South, Virginia. I have a son that's in the United States Army. I am divorced, and I am retired. Regarding the case, personally, I thought it was too many issues. It was a lot of repetitiveness.
Can you speak into the
And it appeared to be this competition going back and forth, like the same thing back and forth. And I don't really think it should have been, I don't feel that it should have been as long as it was. I think that the problem would have been, they could have solved the problem in less time than it took for them to elaborate on it.
Betty, when you say they, are you referring to ACASO and Children's Hospital?
Yes.
Or the
yes,
attorneys
both.
themselves?
No, so and Children's Hospital.
Okay, thank you. My name is Melissa Siu. I am unmarried. I am a professional. I work for the Department of Defense in experimental mobile technology for the warfighter. My opinion was that it was a very interesting case. I think that the plaintiff failed to make a strong enough and effective case on the existence of on a conspiracy. There was, in effect, a contract. In terms of the settlement restraining trade unreasonably, the case was not effectively made.
My name is Mario Jeter. I'm an Army veteran, a native Washingtonian, and based off the facts of the argument, on both sides, they made great arguments, but based off the facts, I can't see where the plaintiffs didn't convince me based off the facts that the settlement agreement harmed competition.
You start with the verdict form. Start with the question number 1. Go around the room. The reasons for the verdict.
Ladies and gentlemen, if you could please take a look at the verdict form. And if you would please draw your attention to item number 1. Take a few moments to read that, and then mark your answer, and then follow with item number 2, and also mark your answer. From the very beginning or from item 1? Okay. Question number 1. Has the plaintiff, Washington Children's Hospital, proven by preponderance of the evidence that the settlement agreement between defendants ACASO Pharmaceuticals Corporation and Generic Corp resulted in payment that was substantially harmed competition? Yes or no? And please indicate your answer verbally and the reasons to substantiate your response, please. Starting with Anila.
My answer to that question is yes. And the reasons why I believe it is yes, though the two,
No, could you use the microphone, please? Thank you, ma'am.
sorry about that. I'll start again. My name's Anila, and my answer to the first question is definitely yes. And the reason I believe that Washington Hospital Center did give us enough information to prove that they did both of the drug companies actually did something which was essentially to harm the consumers. It did not really, even though, yes, they reached a business decision or a business settlement agreement. However, it was to basically kill the competition or give any other company a chance to be able to compete on generic drug for many more years to come. And though they did figure out a way to come to this agreement and keep the larger piece of the pie, Queso did a very good job to be able to keep the larger piece of the pie to themselves and share a small piece with the generic corp. But they together did nothing to actually serve the consumer, which is where the antitrust law comes with its slogan, promote competition and protect consumers. And I think they actually failed on both counts. Their agreement neither promoted competition nor helped the consumer in any way.
Hi, my name's Andrew McDonald. Regarding question number 1, I said no, that that the plaintiff did not prove by preponderance of the evidence that resulted in a payment that substantially harmed competition. I believe that they made a decision that they both that the A company and the G company, that's what I call them. I forget what their names, but the A and the G companies. Basically realized that in litigation they would both go down fighting. They both lose a lot, and I thought that they made a decision to work together. And as the judge said, settlement is always good. It's always good to settle before going to trial, and they did have a settlement. I thought it was a good decision. I don't buy the argument that they were ripping off the consumers for 2 reasons. One, I don't think it's our decision. I don't think it's our right to second guess business decisions. I think it's between the 2 companies. They're there to make money. It's their responsibility, and 2, I think that the payment was. Well, I forgot my second item, but anyway, so I go on to the next one.
Thank you, Andrew. Sophie?
Yes, I said no, that it didn't harm competition, mostly because my biggest beef is that the patent hadn't expired, so there wouldn't be any competition anyway. So the fact that they made this arrangement, I mean, to me, the biggest thing was that the patent had not expired, so there'd be no competition anyway, as I said, and Genericorp was the one who brought suit or said that the patent was invalid to begin with. They were the ones who started the ball rolling. So the fact that, and no one really knew if they could do it anyway, if they could make it. So for me, that was the biggest reason for saying that it didn't harm competition, because there'd be no competition anyway. So the fact that they're in it at all is a big factor for me, and that the consumer and Washington Hospital does get a lower rate. They have that option of getting a lower price for that breathe rate. Maybe not the lowest, but it's much lower than a Queso's or Queso's.
Thank you, Sophie. Michael?
Yeah, Mike Sangelo, I think you made a great point that Washington.
Could you pull the mic
Yeah,
closer,
the
sir?
Washington
Thank you.
Children's Hospital is actually paying less than if there was never a change in at all. If Queso was just continuing to charge $100, so there already was a savings to the consumer. But I think more importantly, there was no other competition. It was mentioned multiple times, and even the fact that Generico may not have even have been successful, the fact that they settled based on the condition that there was a risk to Akeso, and I think it just made best financial decision for all involved, so I picked no for those reasons.
Thank you, Michael. George?
Yes, I picked no because, well, I kind of think there was some validity to Children's Hospital, and that there was no competition before. They both I got kind of confused around. I apologize. The Akesco and Genericorp decided cutting out costs that could have been from litigation. But the fact that Akesco didn't lower the price to Children's Hospital, I think is kind of like unfair. But it wasn't enough grounds for the word dropped out of my head. I apologize,
Harm?
but
Is the word you're looking for harm?
yeah,
Taken out of the statement
I
there?
don't think it's not working in my head, but basically that, yeah.
Okay.
So I think it's no.
Thank you, George. Eric?
Yes, I said no. They were, before all, they were in a litigation. There were big risks with this litigation. There's a large amount of money involved if it goes either way. So it's a normal, as all the parties have said, and the judge has said, that it's normal for settlements to happen, and they encourage it. So then the next thing to do is I looked at the settlement. And in my mind, the settlement seemed like a reasonable amount. Just because, though, as they said, just because it's a settlement doesn't mean it's legal, and it doesn't mean it's not anti-competitive. But if you look at the settlement, in my mind, there wasn't any kind of particular, they talked about payments all the time in this. Did they make a payment? Did they not make a payment? And to me, there didn't seem to be any kind of payment outside of the normal procedure. And again, the words are not hitting my mind exactly how they talked about it, but there didn't seem to be any outside payments that they talked about. These seem to be normal kinds of agreements. Now, maybe some of the prices, the amounts might have been slightly inflated. I'm thinking that they both wanted to make it good for the other side to agree. If you want to make an agreement, you have to sort of, slide the numbers a little bit so the other side will agree. So if it's slightly off, I remember they kept talking about that $5. Is it it's $5 more than maybe what you might expect it to be. But then again, they said, and I agree, the profit margins can vary. There's a variance in profit margins. That's a normal feature of business. So I say that there was not a payment that substantially harmed competition.
Thank you,
it's no.
Eric. Thank you.
Hi. My answer is also no. I don't think there was any harm in competition. I think it was just a business settlement. I think both parties benefited from the business aspect of it. And I think in terms of competition, if there were maybe a third party or fourth party, and maybe they would have reached a settlement that would have taken out another company or put them in a different perspective, then maybe it would have been harmful in competition. But I don't think in this case it was.
Thank you. Tamika?
I said no as well, because like everyone else, I mean, there was no really competition. Like both sides weren't losing nothing. To me, I feel as though it was all about the money. Like it was never who's going to get more, who's going to get less, because like they said, there wasn't. And if you can look, like everyone made a decision before they went to trial, so that can tell you right there that it was all about money. Like, I guess a queso didn't want to lose, and Generico, they didn't. Like, it was, to me, basically, with all the trials, it all just seemed about money. Like, they weren't really thinking about the kids at the end of the day, like, whether they were losing or not, the kids were the ones that suffering. So I just feel as though it was all about money, so my answer is no.
Okay, thank you. Betty?
My answer was no also, and I know this is probably, I'm going to repeat what some has already said, but I also felt that it was like they were in agreement or plan with the business, so who's going to be the better person at the end of the day. And to me, that's like a competition among themselves, not among anyone else but themselves. So I do think that they would consider it as a business and who gets the most money or profit.
Thank you, Betty. My answer to question 1 is also no. I'd like to step back for a moment to the legal definition that the judge shared with us, our responsibility of what we're trying to evaluate here. In my opinion, the settlement was reasonable. The defendant attorneys did prove that the settlement was reasonable and did not do any harm. There was no increase in the end price per unit of the Breathe Right medication to the customer, Children's Hospital in Washington. There was no evidence of an independent or side payment made from Akiso to Generic Corp. There was no harm in the payment that was finally made because it was a settlement agreed upon by both parties. There was no other manufacturer that existed in the marketplace that had the ability to even make the drug. So without Akiso coming to market and registering this patent, if they hadn't done so, the medicine would never even exist. In that regard, I considered that there was no harm. The price did not change. There was no reduction in quality, again, so that speaks to lack of harm evidence. In terms of restriction of the product output, again, if the product never came to market, never was researched or developed, there would be nothing to discuss, so that point would be moot. But because the product was going to be manufactured by another company for a lesser amount in a generic form, which was a bioequivalent, the quality of the product, as was testified by many of the experts in the case, there was no compromise to the product itself. So my vote stands at no. Mario.
I also voted no, and the reason for being, Kuso had if I believe, a 20-year patent that expires in 2018, and with that being said, there was no other competition in the market with the drug that it was selling. So the way I see it, after the settlement between Akuso and General Corp, that brings forth another option for consumers at some point once they after they came to their settlement agreement, after the contract expires, well, the patent 2 years before it expired, they will let General Corp within and start selling the product also with the generic brand of it. So that actually brings more diversity into the marketplace. It brings another person who can sell the same product at a cheaper price also. So I think that's also good for consumers.
Anila, based on what you've heard here, does your answer or response to question 1 change? Yes or no?
No.
Okay. Could you demonstrate to us why?
Well, I just want you, I know everybody made the case that why you think that nobody was harmed or there was nothing wrong happened. Just putting it in perspective, we're all consumers. If each one of us had a child who needed that Breathe Right, the inhaler or the unit, would you rather be paying $40 for it, or would you rather be paying $100 for it? I know the general consumer view is, the attitude is like, oh, well, insurance company covers for it. I don't care whether they pay $100 or they pay $10. I only pay my $5 copay, and I'm going to get it. It doesn't matter. But it does, because cost of insurance is basically paid, the premium of insurance is basically the cost of treatment paid in advance, and it's spread over everybody. 4 of us might have a child who needs the inhaler, but the cost is distributed to all 10 of us. So ultimately, when any company or manufacturer, like in this case, in my rough math of doing the numbers, what they were talking about there, basically they were the Enseco, the original, Enkeso, A queso.
A queso.
A queso. A queso was actually able to guarantee their profits in the 5 years that they were able to, based on this agreement, keep the generic corp out of the competition. Instead of $325 million, because they were making profit in their own manufacturing themselves, they were making $65 a unit profit. They were able to guarantee themselves $375 million profit because they actually just improved their own profit margin by sharing the technology with the generic corp and getting them to do the manufacturing for them. They made it look like that, yes, we're doing it as a favor, we're doing it as goodness of our hearts and all that stuff. But at the end of the day, as you all agreed, that yes, it was a business decision, you have to look at it from a business perspective. If you were in those shoes, a business decision, you're not going to be going out. They didn't go and tell generic corp that, hey, we have 4 other of these patents, so why don't you take this technology too and make them all for $10 less than what we make, and maybe we'll have larger profits. So nothing in this settlement agreement or this agreement that they came to was done for the benefit of consumer. So consumer, which is all of us, was who was violated, and that's what Children's Hospital is actually raising the voice against that. So just keeping it in perspective means consumer didn't really consumer had a loss of more than $300 million. If you look at it from the perspective of being able to let generic corp come in and manufacture the same drug at a lower cost. There might have been some other manufacturers after that. But they wanted to make sure that, hey, instead of you trying to gain speed, they knew that they will gain momentum. They knew that they would possibly lose the case, is the only reason that they initiated the settlement, to guarantee themselves $427 million of profit as opposed to which would have been cut down to maybe $130 million over the next 10 years if by 2012 generic corp would have been able to win the case and start manufacturing the drug. So that's why I still believe that the consumer ultimately is the one that's harmed.
Thank you, Anila, for your comments.
My name is Margaret,
Sophie?
sometimes known as Sophie. I think for me still the biggest thing is you're forgetting that Genericor was the one who jumped in and wanted to start making it. And Akeso is not keeping them from competing or making the generic on purpose. It's just that their patent is valid until a certain year,
2018.
2018. And Genericor was jumping in before that and saying that the patent was invalid. For me, the question that's missing is, it didn't seem like they ever really made their case that it was invalid. They're just they don't want any more, problems.
They who?
Akeso didn't want any more, to battle this out anymore. And instead of waiting for, I think, a certain time period, if I'm not mistaken, if there are a certain number of months go by and no decision is made, Genericor wins anyway. I forget where that is. It says so in here somewhere.
If you don't mind.
Does anyone know what I'm talking about?
Sophie, thank you for your comments. Michael, how do you feel based on what you've heard, the points made both by Anila and Sophie?
It does not change my opinion.
I'm sorry, can't hear you.
It doesn't change my opinion. I still think no.
Okay, thank you. Eric?
My opinion hasn't changed. It's still no. You can't decide this just based on your general feelings or how you feel about the thing. You have to decide by the instructions here. I'm just reading one of them. The existence of a contract or combination or conspiracy between Akeso and Genericorp. You have to think that there was some sort of agreement that's made in a way for a conspiracy, and also that this conspiracy unreasonably restrained trade, and I don't see it that way because it's a trial going on, so it could go either way. Either they could lose everything by having Queso win, and then they have to wait till 2018, or or it could go the other way, where generic court wins. So they saw that they'd better make an agreement because they don't want to go down that route. They don't want to roll the dice. So there's no third party. No one ever talked about any kind of third party. They both agreed that there was no one else out there that was even involved with this. So, you know, so the consumer actually benefited, in my opinion, because if they got in early. They allowed them to start making it in 2016, and I suppose, and at the lower price. So I don't see harm here. So I don't believe it met the
definition.
of saying yes.
Thank you, Eric. Zulma, just one moment. Andrew, did you want to add something, sir?
Well, I thought that that these laws are based on a capitalistic society. Now, this is a business decision, and these people made a decision based on the profit and loss or whatever. But I think it's more of because of a capitalistic society that we have the laws allow businesses to make decisions. I don't think the consumer, I don't want to be harsh, but I don't think the consumer has much of a say in these business decisions. I think
At that juncture, right?
Right.
Okay.
I think that the consumer is involved in the process.
At the front end.
Yeah, right. The business decisions.
Okay.
I mean, they ultimately do it when they purchase it and that. But for us to dictate that the consumer pay a lower rate, it's not the American way. It's not capitalistic. You know, it's more, you know.
So what you're saying is a free market
Communist.
enterprise economy in which the consumer drives the process for payment or the amount of a price that would be rendered for a good or a service. That's what you're saying, right?
I didn't hear the first.
Okay,
part.
so what you're saying is just because this product or service might be used by a consumer does not necessarily give the consumer the right to hold the manufacturer or the originator of the product hostage by saying you must offer this product or service to me at X price.
Correct.
Right?
Correct.
Because it's whatever the market will bear.
Right. That's
right?
that's
And that's
capitalism.
free enterprise.
Right, and that's what our
Okay.
country is based on.
Okay.
That's just my opinion.
Zulma, I saw that you wanted to add something.
Yeah,
Thank you, Andrew.
I still stand by my decision. No, I don't think Children's Hospital proved that there was any harm. I also see that Children's Hospital is also a business, and obviously they wanna be able to gain from a lower price. But that's just like the point you were making about us. You know, if we were using the product, obviously we would rather have a lower price. But if that's not the option and we need it, we will pay for that. So in the same process, Children's Hospital want to benefit from this case also. So they're making their case, but I don't think they made a case enough to show any harm in this case.
So you're essentially saying that Children's Hospital also has an interest. This is not part of the case, but I'd like for you to think of this for just a moment. Do you think that Children's Hospital would charge the patient or the insurance company the $100 for that medication? Because they are also a for-profit entity.
Yes.
And they are interested in what? Markup and profit margins, just like a queso and just like generic court. It's possible, right?
It is possible.
So the basis of what we are responsible for is the existence of a contract or a conspiracy. Anila, I would like to ask you again, did you see or hear evidence of the existence of a side contract or a conspiracy in this agreement between a queso and generic corp?
I did.
You did?
I did.
Can you share with us how you saw that?
It's evident from all the various ways that they all prove that there's a certain amount of price that I like to be able to mitigate competition. It's no different than any other way.
Okay,
It's just that
where-
I always say, like Andrew pointed out, that we are a capitalistic society and all that. That yes, the business is done the same way pretty much everywhere. Some places it's a little more blatant. It's called bribery and whatnot in third world countries.
Okay, I think you're getting a little off topic. I asked you about the existence of a contract. Did you see evidence, convincing evidence, of a contract that existed?
In the agreement that
But
they
that was a
made,
settlement.
No, that was a
settlement
settlement.
agreement that they
A
made.
contract beforehand.
there's no part of that, but that part of the settlement is the agreement. Part of the agreement is the contract to be able to, we'll pay you $5 extra per unit.
That's not the question. Okay, let me try to rephrase. Was there a legal agreement or a contract that existed before the litigants came into court? Would you agree that the product was researched and developed by a CASO?
That's fine.
You agree with that?
That's what
Yes.
is given in the
Okay.
facts.
Was there any other company that had the ability or brought this product to the Patent and Trade Office?
Obviously not. That's the reason, and the patent was weak enough was the reason Generic Corp had the idea or suggestion to be able to penetrate that patent. Just like many patents are issued every day, many of them are penetrated too, just like this.
Sure, okay. Did you see evidence, and can you share with us evidence where the patent was determined to be weak?
It was obvious in their
No,
testimonies.
excuse me. Can you demonstrate evidence? Ms. Maverick said that her company had won
Well, Ms.
and
Maverick has
also
now
had
been
lost. Excuse
Ms.
me.
Maverick had now, Ms. Maverick's statement now is very different than Ms. Maverick's statement was prior to the agreement coming to the table.
Okay, in
One of the very
terms,
important facts that probably was missing might have been helpful, that who initiated the agreement conversation? Obviously, the one who thought would lose, which was the CASO in this case.
Let me try.
Sure.
What would it take for you to change your verdict to unanimous, so that it would be a unanimous verdict?
I can't see it that way.
Okay. All right. Anybody else have anything to add?
Michael, you look like you have something to add.
Not really.
You don't,
Let me
okay.
ask you,
Sophie,
doesn't she
just,
have to answer question 2 as well, if she
Well,
says?
she
Okay.
does, just a moment. We haven't gotten there yet. Sophie,
right.
please. Thank you, Eric.
Well, I know that you think that a CASO.
Could you use the mic,
that
please?
a
Sorry.
CASO wanted to prevent Genericor from entering into the market, but they weren't. They needed to be able to make the product, to make the breathe rate, and they really weren't even sure if they could. I think it was just a bet that they hedged on themselves. Because a CASO did not invite Genericor and say, hey, let's do this. And there's no smoking gun that says that. Genericor took the first step and went to the FDA and said, hey, we think this patent is invalid. But they didn't seem to be under any obligation to actually prove how it was invalid. They just started hashing it out in the court.
We're not part of that trial.
And you're right, we're not part of that. Now it's really just Washington Children's Hospital saying that there's an antitrust. But some kind of, conspiracy to prevent. But I don't see how Washington Children's Hospital thinks that way, because in the end, they wound up, if I'm not mistaken, they can now purchase Breathe Right for a lower price. Is that right?
No.
Did I understand
Once,
there
that?
was
once
no
Genericor
place to
is
be.
able, once the patent expires and Genericor is able to continue manufacturing and marketing the product,
In
then
2016.
yes, they would then be able,
Starting 2 years
2 years sooner.
early.
Yes,
Okay,
ma'am.
so they're just, for the time being, they're just being allowed to make it. But they
Facilitate,
can't
yes.
set the price. But at least now Washington Children's Hospital will be able to buy it 2 years sooner for less money. So I think consumers and children will be saving something. It's not as much as a lot of people would like, perhaps, but I'll try not to go off on a tangent, but yeah.
But is the savings amount that we're talking about here just $5?
No.
I mean,
you mean between the two corporate entities?
let's say it was established that Genericor has state-of-the-art, or I'm putting words in the mouth, has the best manufacturing facilities, or at least right up to.
Well, not at the time. Remember, they did have to spend $1 million to do a tech refresh in their facility, right?
Understood.
So if we also keep that in mind, along with the $3 million that was spent in litigation, that's a total of $4 million.
Yeah, I understand. I was speaking in terms of the consumer and the per cost. So if they're already, let's say, regardless of the startup cost, if we're looking at the time a year from now and when the patent is no longer in force, what is the difference in cost going to be to the consumer? It's going to be, if there's another company or another competition that's equivalent in quality as Genericor, it's going to be $5 difference maybe? So my question is, considering that versus the $70 difference that stands now, in my mind, even though it all seems fishy and maybe there were some discussions in the past, I don't think that it's significant when you look at that disparity of cost at the consumer level.
Okay, I'll see if I can make my point of the significance of the difference.
And then we're going to wrap it up and go in
Okay.
for questions.
We have to
And
do number 2.
now,
Doesn't matter.
like they all very well reiterated, that by the generosity of Akeso, they will allow Generic Corp to come in 2 years sooner than 2018. It's being able to sell ice cream to Eskimos. They're not going to highlight the fact that we're actually going to be able to keep the competition out for 4 more years. So they said by allowing the competition to come in 2 years sooner, the consumer will be saving $84 million. But supposedly at that point the price would go down. So if you see that by the 4 years, as opposed to 2016 or 2018, if Generic Corp would win the case, which they knew they would, is the reason they're proposing this agreement. And in that case, the consumer would be saving $42 million per year for 7 years as opposed to 2. That amounts to $294 million. So there's a $210 million difference to
Could you go
consumer.
back and just read the Sherman Act things that we have to stick to?
Okay, in the interest of time, ladies and gentlemen of the jury, I'd like to thank you all for the very robust discussion of item number 1. I have noted your responses, and I would like to, in the interest of time, move on to item number 2.
Well, we wouldn't go to number 2 because the majority voted
For number 1. So do we?
We're basically done. We're basically done because Anila's already.
That's okay.
pulled out. We're
That's
okay.
So we're going to go back
You
out.
can be
fine.
in.
Ladies and gentlemen, we're
That's
now
why we
going
have
to
jury.
conclude. Thank you.
All right. You guys-
That's why we have the
let's all go
jury
back
system.
out. Let's hear it for our jurors. Yes, we are, and we only have 10 that have been told, so we have to vacate the room at 5. So we can start with some questions, and this is a very spirited group, as you can see. But I want first to ask the jurors, I mean, I know we have Anila who is so articulate, actually everyone wants, so thank you very much. Anila was our holdout, she was our plaintiff. And any questions you have for the attorneys that would help you perhaps persuade you in any way? Where's the mics?
Thank you. One of the key questions I had, which might benefit my fellow jurors, is because who initiated the talks of this agreement?
That's a very good question, and the facts don't say. So that we have. Well, why would that make a difference?
That makes a whole lot of difference, because that goes to tell you who is interested, who has more to lose. They're more sure of their risk is the reason they want to come to this agreement. That, hey, let's make a deal where we can sort of create a win-win, make it look like a win-win, because we make it look like a win-win a lot more than we really create win-wins. And then we make sure that the uninformed consumer remains uninformed for as long as we can keep them uninformed. So.
I'm going to open questions up to the audience. All right?
Well, I mean, if there are no questions, I have a question for the, oh, there is one over there? Wherever it is.
Did the testimony of the economist influence your decision?
The question was, did the testimony of the economist influence your decision?
We have to have respect here.
Oops.
It's important that we keep it nice, please.
Okay.
I actually had an opinion on that. Sitting through the testimony of all these economists, I really think that they were second-party participants that were second-guessing and trying to guess at what was going on. So I really didn't think that their testimony had any effect at all, really. It didn't affect me.
Others?
And I thought just the opposite. Mary, I thought you having credentials and establishing credibility for how long you'd been doing this, your justification, and your answers were not speculative.
How about the attorneys? Questions? Counsel.
I have a question. If the jurors had proceeded to question number 2, do you think that you could have reached a unanimous answer of no to question 2 and therefore reached a unanimous verdict?
I think our response to question 2 would have been the exact same as the response to item 1, which was everyone minus one juror voting.
To be fair, I think Anila is looking at the document now, so.
How would you
Because
vote?
I left my notes back in the room, because it says outweighed by the harmful effects, which were very clear and blatant, harmful to the consumer. Yes, it's very profitable, good business arrangement. You know, if you can't fight your enemy, get in bed with them.
So short answer is no, we would not have been able to reach a no unanimous decision, sir.
One of the questions I have for the jurors is how much it mattered to your internal thinking that Akiso had spent so much money and energy and effort to develop this drug, and it was a big innovation. Did that matter in your thinking?
Okay, it's a split decision. I see.
Yes, it kind of did matter to me because it showed that they put in this the effort and hard work to get this product going, and then it done the proper research. And I think they should have the ability to let the patent. I'm trying to think how I should answer this. Let me see. Yes, in general, yes, run its course. Like, I feel as if the general court was trying to bully his way into a deal with Akuso. So that's my. I can't hear you. Yes, they did.
Yeah, please go ahead.
It mattered to me a lot. It was their idea. It was their baby, yeah, it was theirs.
Well, it made a difference, but I think it could have gone either way because since they spent so much money, they might be more likely to engage in a deal that's not right or corrupt or anti-competitive. So it made a difference, but I don't think you have to hear in my opinion, you have to hear the other stuff to decide.
Hi, and thank you so much for giving your time. It's a lot to listen to, and we lawyers like to talk. But the question I'd be interested in is, it was very clear that most of you did not feel there was actually a payment here. And so if instead, looking at the evidence, you had concluded that that the brand had and that Akiso here had paid $50, $60, $70 million, just wrote a check, how would that have affected your deliberations?
Since I'm holding the mic, I might as well tell you that I believe if there were a separate actual payment, it would have made it much more likely that I would have looked more carefully at it. Anybody back here?
I have a question, if you don't mind. There was a lot of objections, and I think that one of the jurors had made a comment about the fighting or the arguing. Did you find it distracting? And how did it? Okay. How about others? And I want to open it up to our more shy jurors. How about you, Betty? What did you think about that arguing that was going back and forth with the attorneys objecting?
It didn't distract me because I really wasn't paying them any attention. I was
Okay.
trying to, I was trying to comprehend the stuff that I had already heard, so I ignored them.
All right. All right. And when the judge was instructing, how did that impact or influence your decisions or focus your attention? Anyone?
No, I can't say that it did. No.
Okay. All right.
Okay, I want to ask a question.
Please.
When we were talking about the instructions, I believe Andrew or Michael won, maybe Michael asked whether you could take notes, and we squared that away, and I said yes. When you were listening to the proof as it unfolded, and you were sitting there, was there any question that either one of you sat there that I wish I could ask this? And if so, would you share with me what that question was? If you thought of any question you thought, I wish I could ask this. Michael, you have the microphone.
The only thing I kept wondering was how much Casco was really saving by, not saving, but how much the consumer was really saving.
Okay. Yes, Madam Foreperson. Would you pass the microphone forward, Michael?
Your Honor, I wanted to know, why didn't Children's Hospital just negotiate a volume discount buying deal with the Casco themselves and avoid all of this?
Okay.
You're buying the product anyway.
Okay.
Where are your negotiation skills?
Okay, there's a question. Anybody else have a question they thought, I wish I could ask this? Pass the microphone to Betty.
Right.
Betty is on the other end.
My question is, I don't understand how you could promote or sell the same drug for the prices, $30 for one, $100 for the other, and they both be the same drug. Is that possible? Nothing has changed in the drugs. Everything is the same. I know that generics, when you buy regular generics drugs, it's supposed to be different than original or the regular formula. Is this the same as this?
Okay. Of course, I'm not going to answer that question, but I know we have to get out of here in just a second. Yeah, there was another question? And then I want to make a comment. You wanted to answer her question?
They're all impacted by that because drugs fall
Okay.
into more than one category. They're either considered formulary, which is a proprietary branded drug that is the highest cost drug, or generic.
Okay.
And every single person who has insurance, who's ever went and bought a medication, you're impacted by that. And it's seamless, it's invisible, you don't know it.
Okay. Yes, Anila.
That's what brings me to my point, that why, as consumers, we can't see the difference of consumer losing $210 million in this whole deal that the
Okay.
two companies came to, and we think that they're right.
The only reason I asked you that question, though, because I wanted to make the point that two things. I told you at the outset this was a radically compressed presentation. There's a lot of information that the parties would have brought out had this been a regular elongated trial. But I also know that parties to this litigation live with it day in and day out. They've had it a long time, and they are producing for you a set of events from time past and presenting it to you in time present. And sometimes, because they've been so close to it for so long, there are blind spots. And I wanted to just find out whether there were any blind spots that were obvious. And I think from this compressed stage, I did a good job because I haven't heard those blind spots. And I'm just sort of testing that because I'm always sitting in the middle of sort of the translator or whatever. But thank you. Gil?
Yep. I think this is going to conclude our program, but thank you very much, ladies and gentlemen, the jury. Thank you to the audience. Thank you to these attorneys, these great attorneys. Thank you, Your Honor. It's been a pleasure. All right.